What's the color of the one you got? Pink one? Okay, well, there's another pink one from Picture Blue. It's crazy. It's so fun. Anyway, Jay, this is okay. One is a picture and one is a clip. You should have
Test, test.
the last one I sent. Is it like the white one?
Good morning. Good morning. Good morning.
Good morning.
Good morning.
Just very cute. We gotta get you guys enrolled in the dance thing or something, so you can go do the dance. Yeah. Uh-huh. Oh, yeah, for sure. Why is it hard?
Okay. Again, apologize for the delay. I'm Bruce Thompson. I am Chair of the Water Quality Control Commission. We're starting our meeting today on May 13th. I'd like to welcome everybody. It looks like it's going to be a rather full day. So the first item on our agenda is a roll call. Ms. Jones, would you call the roll?
Yes, I will. Good morning. Commissioner Brankard, are you present?
Present.
Commissioner Candelaria has let us know he's not going to be here, so I will record him as absent. Commissioner Dominguez,
Present.
Commissioner Fry,
Present.
Commissioner McWilliams,
Present.
Commissioner Paladugu, Commissioner Patton,
Present.
Commissioner Rosatos,
Present.
Commissioner Velasquez,
Present.
Commissioner Vigil,
Present.
Commissioner Zemlik,
Present.
Vice Chair Armstrong, Chair Thompson.
Present.
Chair, you have a quorum.
Thank you. So the second item on the agenda is approval of the agenda for today's meeting. I would entertain a motion to approve.
Motion to approve the agenda. Second.
Been moved and approved, moved and seconded. Any discussion? Hearing none. This requires a roll call vote. So let's do the roll call.
Okay, thanks. I want to confirm, was Vice Chair Armstrong, did you made the motion, and Commissioner Brankard, you were second. Thank you. So Commissioner Brankard, how do you vote?
Yes.
Thank you. Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Paladugu,
Yes.
Commissioner Patton,
Yes.
Commissioner Rosatos,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vigil,
Yes.
Commissioner Zemlik,
Yes.
Vice Chair Armstrong,
Yes.
and Chair Thompson.
Yes.
Motion passes.
Thank you. Third item on our agenda is approval of the minutes of the March 12th meeting.
Mr. Chair.
I would make a motion to approve the minutes as presented.
I second.
Been moved and seconded. Discussion? Changes? Okay, let's have a vote on that. Again, I think this is a roll call vote.
Okay, thank you. And can I confirm who made the second? Thank you. Commissioner Brankard, how do you vote?
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Paladugu,
Yes.
Commissioner Patton,
Mr. Chair, I'm going to abstain as I was not present.
Commissioner Rosatos.
Yes.
Thank you. Commissioner Velasquez,
Mr. Chair, I too will abstain. I was not present.
Commissioner Vehil,
Yes.
Commissioner Zemlik,
Yes.
Vice Chair Armstrong,
Yes.
and Chair Thompson.
Yes,
Chair, the motion passes.
thank you. Agenda item 4 is public comments, and these are general comments not pertaining to the meeting agenda. So if you want to make comments about the proposed reuse rule, that is not appropriate. So I would ask if there's anyone that wishes to make public comment. Hearing none, let's move along. Agenda item number 5 is WQCC 23-65. It's Carly LLC's application for a stay of proceedings pending the appeal of Adams Cleaners, and it's versus NMED. We've got a public hearing scheduled. However, there have been some motions that were introduced to either stay or, to stay the proceedings. So I think before we have the public hearing, we'd like to hear the discussion of the motions. And I believe it was the NMED that filed that motion.
Chair Thompson.
Oh, yeah, it wasn't me. And that
So
filed,
it was filed by Ms. Weatherly.
I think they're on the platform.
Is Mr. Nasco also on the video call? Ms. Weatherly, are you present? Mr. Nasco, are you present? So we don't have the parties. Perhaps it'd be appropriate to table this item. Does that require a motion? Okay. A motion to table.
Mr. Chair, I would make a motion to table in regard to WQCC 23-65 CO.
I would move to second.
Okay. Been moved and seconded to table WQC 23-65. This will again require a roll call vote.
Very good. Commissioner Brankard, how do you vote?
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Paladugu,
Yes.
Commissioner Patton,
Yes.
Commissioner Rosatos.
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlik,
Yes.
Vice Chair Armstrong,
Yes.
Chair Thompson.
Yes.
The motion passes.
Okay, thank you. Agenda item 6 is a public hearing on WQCC 23-84, which is the new proposed rule 20-0.6.8 NMAC water reuse regulations. There has been some concern about potential conflicts of interest on the parts of the commissioners or whether or not some of the members have filed the appropriate paperwork to serve on this particular aspect. So at this point, council has recommended that we go around the table and all the commissioners state whether or not they have any real or perceived conflicts of interest regarding this. So I'd like to start this off as chair. I have numerous acquaintances, people I've worked with on both sides of the issues. However, I have no professional conflict of interest, nor do I have any financial conflict of interest in this particular issue. So let's start down. We'll just go around the table. We'll start with the Commissioner Zemlik.
No, I do not have any professional or financial conflicts of interest. I have no professional or financial conflicts of interest. Bonnie Fry.
Larry Dominguez, no professional, financial, or perceived conflicts of interest.
Krista McWilliams, I have no conflicts of interest, professional or otherwise.
Srikanth Paladigu, I have no professional or financial conflict of interest.
Jonas Armstrong, I have no professional or financial conflict of interest.
Kirk Patton, I have no professional or financial conflicts of interest.
William Brackett, I do not believe that I have any conflicts of interest relevant to this proceeding.
Toby Velasquez, I have no financial or professional conflict of interest. However, I do have a personal conflict of interest, and I will recuse myself because of it.
Edward Vigil, I have no professional or financial conflicts of interest in this matter.
Chair Thomas, did you want me to also?
Oh, I'm sorry. Commissioner Zatos.
No, this is Gerasimus Rosados. I have no professional or financial conflicts of interest either.
Thank you. Yeah, we were just talking, Commissioner Armstrong and I, New Mexico is a small state, which is one of the nice things about it. Many of us know each other. But I think it's worth getting on the record that we don't have any conflicts that might influence our participation in these deliberations. So at this time, I think we're going to have a public hearing. We have appointed Miss Felicia Orth as the hearing officer. And unless anybody has concerns, we'll turn it over to Miss Orth.
Thank you very much, Chair Thompson. Am I echoing a little bit? Move that away. All right. Good morning. My name is Felicia Orth, appointed by the Water Quality Control Commission to conduct a hearing in WQCC 23-84R for rulemaking. This is a proposed rule 20.6.8, ground and surface water protection supplemental requirements for water reuse. The Environment Department Water Protection Division is the petitioner. As probably everyone knows, there's been an awful lot of activity in the matter already, lots of parties. So I'll just mention a few things briefly. One, the rulemaking proceeding will be conducted in accordance with the Commission's rulemaking rules set out at 20.1.6. There are some respects in which we have adjusted the requirements in those rules. I entered one long pre-hearing order. We also had a pre-hearing conference last Wednesday, and there has been a fair amount of email traffic in which I've made some decisions that will be relevant to how we proceed. And I'll raise those as we go along. For example, Sir rebuttal. If it's proper Sir rebuttal, we're going to hear it. If it's not proper Sir rebuttal, we won't hear it. We have 17 expert witnesses. To the extent they have pre-filed both direct and rebuttal, they'll make that presentation at the same time so that we're not going back and forth with the witnesses at different times of the week. We will make a couple of accommodations for witness availability and travel. You'll hear about that. For now, though, what I'd like to do is ask folks for their appearances in the order in which I will ask them to offer their presentations. So for the petitioner, Mr. Knight.
Morning. Good morning, Madam Hearing Officer, Mr. Chairman, Commissioners. My name is Andrew Knight. I'm an Assistant General Counsel with the New Mexico Environment Department, and we are here to propose 20.6.8 to you today. And I've brought 5 witnesses with me, which we will bring up and introduce individually. And we look forward to the hearing. Thank you.
Thank you, Mr. Knight. Ms. Fox?
Good morning, Madam Hearing Officer and Commissioners. My name is Tanis Fox, and I'm a lawyer with Western Environmental Law Center, and I'm here today representing Amigos Bravos and Sierra Club. Thank you for your time and your work.
Thank you. Ms. Nanasi?
Good morning, Madam Hearing Officer and Chair Thompson and Commissioners. My name is Mariel Lanassi. I represent New Energy Economy. And with me today is Christopher Dodd, who also represents New Energy Economy. Thank you very much.
Thank you. Mr. Davis?
Good morning, Commissioners. Madam Hearing Officer, my name is Tim Davis. I represent Wild Earth Guardians in this matter.
Thank you. Ms. Evans or Mr. Cox?
Morning, Commissioners and Madam Hearing Examiner. My name is Colin Cox. I represent Center for Biological Diversity in this matter.
Okay, thank you. And we do have 3 individual entries of appearance that I will call immediately following Center for Biological Diversity. They may or may not be on the platform and have already said that their intention is to offer public comment, but they did enter appearances as individuals. So I will call them. This is Mr. So, Mr. Atencio, or Mr. Sage.
Madam Hearing Officer, my name is Mario Atencio, representing myself, and will present public comment. Thank you.
Thank you. Pause a moment in the event Mr. So or Mr. Sage are on. No? All right. Let's see. Ms. McCaleb or Ms. Taylor?
Good morning, Madam Hearing Officer. Good morning, Chair. Good morning, Commissioners. My name is Liz Newland Taylor, and I'm representing Select Water Solutions. Thank you.
Thank you. Is Mr. Hightower with us?
Mr. Hightower is present, but at the moment he is out.
All right. Give me your name for the transcript.
Stephen Hightower.
You are Mr. Hightower.
Stephen Hightower.
You're
You're looking
not
for
me.
Mike.
Yes, I am. All right, thank you. Let's see, Mr. Maxwell.
Good morning, Your Honor, members of the commission, and esteemed members of the public. My name is Nicholas Ray Maxwell, entering my appearance into this matter. And
Thank you,
I hope
Mr. Maxwell.
to make statements. Thank you.
Thank you. And Mr. Wexler.
Morning, everyone. Nice to see you. Jeff Wexler on behalf of the New Mexico Oil and Gas Association.
Thank you very much. All right, so we have the appearances. The rules are the same as with most of our hearings. Testimony is taken under oath and subject to cross-examination. Commissioners will have an opportunity to ask their questions of the witnesses. All of the parties who just entered their appearances will have an opportunity to ask questions as well. We will, because the rules require that for every day of hearing, we set aside a time to accept public comment. We've tried to be organized about that, and we have a sign-up sheet at the back of the room where you can indicate. For today, there are 2 public comment periods. One is at noon and one is at 5. If you would like to indicate your desire to speak at public comment, please sign up on either the first or second page. We will have public comment again every day. No decisions will be made this week by the commission. They are your decision makers, but we are going to have a post-hearing process, meaning the parties will be able to submit post-hearing submittals. The chair has requested a report, and then all of that will be bundled up for the commission's deliberations at a subsequent meeting. We don't know when that will be, but every party will be notified of when that will be. And we can talk more about the post-hearing process at the end of the hearing, which I sure hope is this week. We begin with opening statements. The parties, commissioners, the parties have the option of presenting their opening statements right now or of deferring the timing of their opening statement to immediately prior to the presentation of their case, and that's in their discretion. So we will start with Mr. Knight.
The microphone. The microphones are very sensitive. Note to all future users of them. Good morning once again. My name is Andrew Knight, and I'm here to present 20.68, our proposed supplemental requirements for water reuse. The department is here today to propose a new part to the ground and surface water protection regulations. This week, we are all going to learn a lot more about water reuse, different kinds of water reuse, including domestic wastewater reuse, direct and indirect potable applications, industrial wastewater reuse, and produced water reuse. The proposed rule creates a framework and definitions for all of these types of reuse, which will allow the commission to build out regulations for each type of reuse in the future as it sees fit.
Oh, my boy. My boy too.
Right. The objective of the rule as a whole is to control discharges of water contaminants specific to water reuse. The rule is supplemental to the regular ground and surface water protection rules, meaning that all of the standards and requirements of those rules still apply to any activity carried out under the proposed rule. The rule is prohibitive when it comes to discharges of any type of produced water, whether treated or untreated. That is because at present, there are just too many unknowns to allow the department to propose standards or specific permit conditions or to permit any discharge of treated produced water in a way that is protective and that complies with the Water Quality Act. At this point, we couldn't even tell you what testing would be needed to determine that a certain treatment technology or combination of technologies would be protective. The 3103 standards in our existing regulations are wonderful, but they only include contaminants that are likely to be found in traditional ground and surface waters. For this reason, treated produced water could theoretically meet all 3103 standards and still not be safe to discharge. While the department was developing this reuse rule, the legislature passed the Produced Water Act, which you will hear a lot more about, and which provides that any reuse of produced water outside of the oil and gas industry will be regulated by this commission and will be done pursuant to a permit issued by the department. This reuse rule has been a huge effort on the part of a lot of people within the department. It has been a multi-year effort. The department convened an advisory committee, drafted a rule, took public comment, and engaged in extensive stakeholder outreach. Throughout this public process, what we somewhat reluctantly came to realize is that the science regarding treatment of produced water is just not there yet. The scientific research that would allow us to protectively permit treated produced water discharges simply does not exist. So we have proposed a rule that creates a framework in which pilot projects and demonstration projects involving produced water can be conducted in a way that is protective of ground and surface water as defined in the Water Quality Act. The proposed rule requires that the knowledge gained from these demonstration and pilot projects be shared with the department to facilitate further regulation development. We have attempted to create a rule that is as protective as possible while still allowing the science to advance through pilot and demonstration projects that will provide us with the data, reliable and reproducible data that will allow further development and deployment of reuse technologies. Each of the definitions in our proposed rule is important. A great deal of time was spent internally debating and deciding which definitions to propose and which to include in this rule, and the exact words used in each definition that was new. Some of the definitions appear elsewhere in our regulations, but we feel it is extremely important that those definitions also be included in this Part 8. As always, we think that the rule we have proposed strikes the perfect balance. And while we urge you to adopt it exactly as we have proposed it, I think what is really more important is that you adopt some version of the rule after this hearing that clearly prohibits discharges of any kind of produced water outside of the oil and gas industry, but that also allows for development and testing of treatment technologies and general advancement of our understanding of this topic. The witnesses you will hear from the department today are among the most qualified people anywhere to talk about this topic. There is probably around a century of collective experience between these people permitting and regulating discharges to ground and surface waters of New Mexico. This opportunity to acknowledge the tremendous amount of hard work that is on the part of our staff that has gone into bringing us to the point where we can propose this rule today. And just want to say that we are lucky to have these people. In closing, I would just like to say that we don't know what the future holds. Some types of water reuse may turn out to never be practical. Other types may develop in ways we have not anticipated. But what seems clear is that water reuse in some form is going to be important in the future. And there will be continued pressure and continued incentive to develop these technologies in New Mexico. Produced water in particular is a problem that needs to be solved. And there is a great diversity of strongly held opinion as to what the best ways to go about that are. But I just invite you to listen to all the testimony and, reach the conclusion that in your minds is the most practical and pragmatic and what's best for New Mexico, as you always do. With that, I would like to call my first witness. Is that not yet? Or other opening statements?
There may be. I'm going to check.
Okay. That's what I had in my script. So
Thank you, Mr. Knight. Ms. Fox, would you like to make an opening statement now?
Commissioners, Madam Hearing Officer, again, my name is Tanis Fox. I'm a lawyer with Western Environmental Law Center, and I'm here today representing Amigos Bravos, a statewide water protection and conservation nonprofit organization, and Sierra Club, a national nonprofit organization dedicated to promoting the responsible use of the Earth's ecosystems and resources. Amigos Bravos and Sierra Club strongly support a prohibition against discharge of treated and untreated produced water to New Mexico ground and surface waters. Our evidence will show that discharge of produced water, whether treated or untreated, to our state's precious water resources is not protective of human health and the environment. We will present two witnesses, Dr. Christopher Lewis, an expert in risk assessment, and Charles DeSalen, an expert in legal drafting. Dr. Lewis has a doctorate in environmental health from the Harvard School of Public Health. He works for Industrial Economics, Inc., which is an international consultancy with expertise in natural resources, policy, and economics. Dr. Lewis has a wide range of experience working for national, state, and international agencies, and has a great deal of experience working in New Mexico. He's been lead for the last 14 years for the natural resources damage assessment for releases of hazardous substances and oil from the historic operations of Los Alamos National Laboratory. Dr. Lewis has conducted a survey of peer-reviewed literature on the toxicology and treatment of produced water. His findings are consistent with those of the expert witnesses from the New Mexico Environment Department. And that is that given the hazards and potential risks associated with discharge of untreated and treated produced water, the treatment technologies available, the lack of information on the precise constituents that are in produced water, and the lack of information on the human health and ecological toxicity of many of the constituents of produced water, a prohibition on discharge of treated and untreated produced water to New Mexico ground and surface water is prudent and warranted in order to protect human health and the environment. Dr. Lewis grounds his opinions in science, and it is the science and protection of human health and the environment upon which the commission must base its decision. The science tells us that the chemicals in produced water vary wildly from well to well, operator to operator, geologic formation to geologic formation, basin to basin. A seminal article on the characteristics of produced water, the 2020 Danforth et al. Article, which is NMED Exhibit 133, and discussed by Dr. Lewis and the NMED experts. In particular, Dr. Lehue finds that there are 1,198 individual chemicals potentially found in produced water. Wow. The chemicals in produced water range from hydrocarbons, salts, metals, and radionuclides. They include known hazards such as arsenic, barium, bromide, mercury, as well as benzene, toluene, ethylbenzene, and xylenes. These particular constituents have the potential to cause carcinogenic, developmental, reproductive, and other adverse effects in humans and other biological organisms. As just one example, a recent meta-analysis found that the maximum concentrations in produced water of benzene were 860 milligrams per liter. That's 860. While EPA's standard for aquatic life for benzene is 5.3 milligrams per liter, and the federal maximum contaminant level for drinking water is 0.0005 milligrams per liter. What can be found in produced water is multiple orders of magnitude higher than EPA standards. But it's worse than that. Benzene is carcinogenic, and its maximum contaminant level goal for drinking water is 0. The New Mexico Oil and Gas Association and Mike Hightower claim repeatedly that treated produced water is safe to discharge as long as New Mexico water quality standards are met. But NMOGA witnesses and Mr. Hightower failed to acknowledge that the Commission's current ground and surface water quality standards do not include many of the potentially harmful chemicals in produced water. How can produced water be treated to standards if there are no standards? NMOGA witnesses and Mr. Hightower are bereft of any explanation. Dr. Danforth, along with her then colleagues at the Environmental Defense Fund, actually compared the potential constituents in produced water with the constituents for which there are New Mexico ground and surface water standards under this commission's rules. They even excluded potential constituents for which there are no standardized analytic methods to identify them. Their analysis found there are many potentially hazardous chemicals in produced water for which there are no New Mexico water quality standards. This analysis, which was submitted to NMED for the Commission's last triennial review, will be introduced as ABSC Exhibit 11 in Sir rebuttal to NMOGA testimony, and it was dropped in the drop box that the parties and the commissioners and the hearing officer have access to yesterday. The bottom line, commissioners, is this. The New Mexico Environment Department's proposed prohibition against discharge of treated and untreated produced water to ground and surface waters in New Mexico is supported by the science and should be adopted by this commission. Now, Amigos Bravos and Sierra Club do take issue with some of how this rule is drafted. And Mr. DeSalin will explain to you why this is and propose changes to simplify, clarify, and streamline the rule. This testimony is important. The rules passed by the commission are its work product, and any rule, which of course carries the force of law, must be clear, well drafted, and comprehensible. Mr. DeSalen, in his direct and rebuttal testimony, methodically walked the commission through why each of his proposed changes to improve the rule is warranted. We hope you consider each of his recommendations. He is one of the foremost authorities on drafting regulations in New Mexico. Amigos Bravos and the Sierra Club have provided a red line strikeout and a clean copy of the language we propose. Those are exhibits 1 revised and 2 revised. I hope you will agree that the revised rule we propose is an improved product. A point of disagreement between Amigos Bravos and Sierra Club that Mr. Knight alluded to in his opening statement and NMED is the inclusion of defined terms that are not used in the body of the rule or that are only used in another definition. Mr. DeSalen, legal scholars, and the Legislative Counsel Services drafting manual, which must be looked to by this commission for guidance in drafting its rules, are all in agreement that such definitions have no place in rule. During the last triennial review, the commission unanimously agreed. Some of you may remember that during that proceeding, NMED proposed definitions for base flow and effluent dominated, terms that were not used in the substantive regulations. Amigos Bravos, a party in that proceeding as well, objected to their inclusion because they served no regulatory purpose. The commission agreed, unanimously voting not to include those definitions. We have included the commission's deliberations and vote as our Exhibit 8. Then the department tried to justify those unused definitions and rule to clarify policy documents. Now the department tries to justify these definitions and rule to clarify permits, but the department's justifications are vague. And Mr. DeSalen explains the new rules will not apply to existing permits. And there are other appropriate mechanisms for making permit terms more clear, including issuing department guidance and amending the permits themselves. A significant problem that has arisen from including these unused definitions in the rule is this. Many of the definitions define land applications of reuse water. These include agricultural application, food crop application, irrigation application, and land application, to name a few. The public, understandably, is concerned that the rule allows land application of produced water, and that produced water will infiltrate and pollute groundwater. This is not what the rule says, but it is what members of the public are concerned about. From a public perception viewpoint and from a legal drafting viewpoint, more importantly, it makes more sense to craft these definitions if and when there is regulatory context to assess, evaluate, and craft appropriate definitions for these terms. This rule, in closing, is few in numbers of words and pages, but will nonetheless have tremendous impact in New Mexico and, quite frankly, beyond the four corners of the state. New Mexico should lead based on the science and the evidence presented to the commission. Amigos Bravos and Sierra Club, thank you for your time and hard work on this important rule.
Thank you, Ms. Fox. Mr. Nasi? Mr. Dodd.
At this time, New Energy Economy defers its opening statement until its presentation of witnesses. However, we would ask that our motion to cure jurisdictional infirmity be heard prior to proceedings in this matter.
Excuse me. I believe the discussion earlier in which every commissioner spoke to whether they believed they had a conflict was meant to address that motion. But let me turn the response to your request to the chair and Ms. Miller.
Thank you. I've been advised by counsel that we don't have to make a jurisdictional determination. And so I think I'm going to let the record stand that if all of the commissioners have stated that they don't have a conflict, and we'll leave it at that.
Thank you, Mr. Chair. Thank you, Mr. Dodd and Ms. Nanasi.
Thank you, Mr. Chair.
Mr. Davis.
Thank you, Madam Hearing Officer. Good morning, Commissioners. Again, my name is Tim Davis. I represent Wild Earth Guardians in this matter. And while this rule proposes a prohibition on the discharge of treated and untreated produced water, it still fails to meet its purpose of regulating reuse water in a way that protects groundwater and surface water in New Mexico. So before I go any further, I want to give you a quick roadmap of why that is. First, it doesn't regulate reuse water in the same way that it does produced water. There is a prohibition on the discharge of produced water, whether it's treated or untreated, but not on reuse water. Second, it fails to provide sufficient standards for treatment and data collection. Third, it permits the use of undisclosed chemicals in demonstration and industrial projects. And fourth, it doesn't protect our freshwater resources from the new waste streams that are going to be created through the treatment process. So I'll start with the reuse water issue. And part of the issue here is that reuse water is defined as treated produced water that is appropriately treated. And there's no standard for what appropriate treatment is. And it does not also say who makes that determination. There's also the issue that you've heard about briefly this morning with industrial projects. And these are demonstration projects without a cap of scope or scale. And given the limited data that we have on treatment of produced water, it's just not appropriate at this time to allow industrial projects. So Guardians would ask a couple of things here. When you adopt a rule, we ask that first, it prohibits the discharge of reuse water, in addition to the prohibition of discharge on treated and untreated produced water. Second, we ask you to adopt a rule that gives standards for what appropriate treatment is for something to become reuse water for any of the contemplated end uses that this rule may have. And third, we ask that you just strike any reference to industrial projects in this rule. It's just premature to contemplate industrial projects in this proposed rule. Next, I'd like to address the data and treatment standards. Instead of providing scientifically based standards for demonstration project treatment and data collection, the rule leaves the decision of how to treat, report, and collect data up to the project proponents themselves. So we would ask that the Commission adopt a proposed rule that includes standards for demonstration projects based on the best available scientific protocols. As an example, the New Mexico Produced Water Research Consortium's document called Guidance on Produced Water Sampling and Procedure could set a minimum regulatory baseline for data quality and assurance, which requires testing at each stage of the treatment train. Likewise, the Commission should adopt a rule that includes standards for handling, testing, and evaluation of produced water data that apply to all demonstration projects to ensure accuracy and conformity of data sets. Next, the proposed rule allows the use of undisclosed chemicals in demonstration projects. The Commission can adopt a rule that protects our surface and groundwater from these undisclosed chemicals under its existing authority. And how would it do that? It can ban the use of produced water, source produced water, that comes from wells where there are undisclosed and trade secret chemicals used. This is important because when you disclose chemicals on the front end of the treatment train, you can use targeted testing to quantify those chemicals. You know what you're looking for. When they're undisclosed, you have to use less accurate testing methods to try to identify undisclosed chemicals. In other words, you don't know what you're looking for. And it's also important to note that while these chemicals are often referred to as unknown chemicals, that's not entirely accurate. These chemicals are unknown to you, they're unknown to the department, they're unknown to me, but they're not unknown to everyone. Others, like manufacturers who do know what is in their frac fluid, for example, could disclose those if they're required to do so. But to be clear, we are not asking this commission to try and require disclosure in any way. You can use your existing authority to ban the use of any undisclosed chemicals. So if the source water has undisclosed or trade secret chemicals in it, it really shouldn't be used in these demonstration projects. Next, this proposed rule is going to create new waste streams. So the proposed rule directs project operators, demonstration project operators, to dispose of their treated produced water back to the oil field via OCD permitted facilities. The rule then makes a provision for other methods of waste disposal on a case-by-case basis, but it does not outline what should be considered on a case-by-case basis or who makes that decision. So we'd ask that that provision be stricken, the case-by-case basis provision. Let's also remember that demonstration projects can occur off the oil field. Treated produced water goes through stages of treatment that could use undisclosed chemicals, can change the chemical composition of the source water, and ultimately, reuse projects are for purposes that are unrelated to the exploration or production of oil and gas. So it's anything but clear whether the treated produced water that comes out of these projects, the new waste stream, the reuse water, it's unclear if that's actually still oil and gas waste. So I can imagine a scenario in which a project proponent takes their treated produced water back to the oil field, but that treated produced water being disposed of at an OCD facility could violate state, federal, or local law. Because again, it's changed its chemical composition. It's been brought off the oil field and it's being used in a process that is not intended for the exploration or production of oil and gas. There's another provision in here that directs all components of a reuse project to be disposed of, ultimate disposition, that's applicable state, local, and federal law. So I think to make this clear, we should require that all treated produced water, reuse water, make it clear that those are components of a reuse project that have to be disposed of under applicable state, federal, and local law. And we also have to make sure that there is a strict prohibition on the discharge of reuse water and that treated produced water is not returned back to the oil field for its ultimate disposition. So in closing, Guardians makes the following request: that you adopt a rule that prohibits the discharge of produced water, treated produced water, and reuse water to surface and groundwater. We ask you to adopt a rule that establishes standards for what appropriate treatment is to basically turn treated produced water into reuse water. We ask you to adopt a rule that includes standards based on the best available science for produced water testing, treatment, reuse, and data collection. We ask you to adopt a rule that does not allow industrial projects. We ask you to prohibit the use of source-produced water from wells where undisclosed or trade secret chemicals are used. If there's undisclosed chemicals, that source water should not be used in demonstration projects. And last, we ask you to strike provisions that direct demonstration project waste, including treated produced water, to OCD disposal sites, and instead require compliance with all federal, state, and local law in the final disposition of treated produced water, reuse water, and new waste created by demonstration projects. As I stated earlier, these new waste streams may not be exempt hazardous oil and gas waste when they result of new processes unrelated to the exploration and production of oil and gas. And in closing, I would just ask that the commission allow guardians to submit a final red line at the conclusion of this hearing to provide the commission with the specifics of how guardians would ask you to implement these requests. Thank you for your time and attention.
Thank you, Mr. Davis. Mr. Cox?
Thank you, Madam Hearing Officer and Commissioners. I'm going to defer my opening statement until we come up in the order of testimony. If that's all right.
That's fine. Thank you very much.
Thank you.
Ms. Taylor?
Thank you. Good morning again, Commissioners. As I said before, I'm Liz Taylor, and I represent Select Water Solutions. Just to give you a little background, Select is a leading provider of sustainable water and chemical solutions to the energy industry in New Mexico, Texas, and around the country. Today, or at this hearing, Select will not be presenting witnesses itself, but I will be participating. Select has infrastructure, chemical manufacturing, and water treatment and recycling capacities and continues to build those out. Nationally, Select's supply of treated or recycled water to the energy industry exceeds 17 billion gallons of water. 17 billion. For those of us in New Mexico, that's more than 52,000 acre feet. A lot of water. Treatment and recycling are expanding water sources for the energy industry. Recycled water also shows promise to support industrial, agricultural, and domestic uses. But expanded uses must be safe and environmentally responsible. Adopting good water reuse regulations is critical to extend the life cycle of water through treatment and recycling while protecting public health and the environment. Good regulations need 3 ingredients. They must be comprehensive, they must be scientifically sound, and their development must include all interested stakeholders. These regulations fail to meet all 3 of these criteria to be good regulations. The regulations are not comprehensive. They address only the reuse of produced water, not domestic water or industrial water. As important, and as you've already heard, the water quality standards are absent. Consequently, the regulations are not scientifically sound because there's no science in them. The water quality standards simply have not been proposed yet. Finally, the development of the regulations failed to include interested stakeholders and the public. After an initial flurry of public meetings back in 2019, the stakeholders have not been involved. For example, the department failed to hold stakeholder meetings to explain the regulations before initiating the public comment period in November. Since November, we have seen 4 different proposed regulations just in the past 6 months, including significant changes that were made in the rebuttal testimony that we got last Monday, just a week ago. The regulations, therefore, fail to meet the criteria to be good regulations. And the regulations are not necessary. The department currently authorizes demonstration projects, and those projects can produce the science needed to develop the standards. Select has a concern, shared by others, that the proprietary information developed in the projects must be protected for trade secret and proprietary reasons. So far, the department has not made efforts to protect this proprietary information. Also, to justify these regulations, the department argues that the regulations are needed to, quote unquote, close a loophole in the current regulatory scheme. But this loophole is an imagined loophole. If treated produced water fails to meet water quality standards, especially if the standards don't exist, then the department can deny the 401 certification needed to discharge the permit. The department apparently wants a regulation to be able to deny a permit based on the source of the water, not its quality. But neither the Water Quality Act nor the Produced Water Act permits such a regulation. New Mexico certainly needs additional sources of water, and treated produced water could be part of the solution. These proposed regulations, however, fail to provide a step toward that solution. The petition should be denied, and the department should be instructed to engage with stakeholders to develop a comprehensive, scientifically sound set of regulations. Thank you.
Thank you, Ms. Taylor. Is Mr. Hightower with us? Mr. Hightower, if you would first please enter your appearance.
To be honest with you, I've never been in one of these. So what is that?
All right.
I apologize, but I spend a lot of time in the academic side. I really haven't been to one of these hearings, so
That's all right.
if you'll lead me, I'll follow.
All righty. If you would give us your name.
My name is Marion Michael Hightower.
Thank you. And on whose behalf are you appearing in this hearing?
I'm appearing on my own behalf. I've done work in produced water and desal for 25 years.
Okay.
And so I'm presenting, my presentation will be about the activities over the last 25 years, but I'm currently the director of the New Mexico Produced Water Research Consortium, but I'm also been on boards for the New Mexico Desal Association, and am an emeritus from Sandia National Laboratories, where I did work for the Department of Energy and produced water and desal.
All right. So as I understand it, just to be very clear, you're not here on behalf of DOE, Sandia, the consortium, or the organizations you've worked with.
No, I'm not. I'm going to provide information on results from all of that work over the last 20 years, but not representing any one of those organizations. No.
All right. So that's the entry of appearance. And the other thing you can do while you're there at the table is to offer a brief summary of what your testimony will be later this week.
Okay. Real quickly, and I've provided that notice of intent to present. And I've given about 25 pages of background information for the last 20 years. Presentation that I will be giving will add more detail of the last 20 years of work looking at non-traditional water resources and how those water resources can be utilized to support water stewardship for both the state of New Mexico, the Southwest, and work that I've done internationally and nationally for the Department of Energy. So I see produced water as a brackish water, saline water, very similar to other waters that we're looking at around the country and around the world as alternative supplies to support additional resources to support surface and fresh groundwater, fresh surface water. So I see produced water very similar to what I look at in other waters, is opportunities there to improve water supplies by treating these waters to a level that meets current standards. State of New Mexico has current water quality control standards for a number of fit-for-purpose applications. And what I've been able to see through my research over the last 20 years is that we can meet those current regulations for those fit-for-purpose applications with current technologies We can do that with brackish water. We can also do that with produced water. So the work that I've done suggests that the technologies are there and the cost performance of those technologies exist to allow us to treat these non-traditional waters to support new supplies for the state of New Mexico. Fair
Thank
enough?
you very much.
Okay, thank you.
Mr. Maxwell.
Your Honor, I'll defer my opening statement until I make a case.
All right, thank you very much. And Mr. Wexler.
Okay, we'll also defer our opening statement until our cases. I would ask, however, Your Honor, that the Environment Department disclose when and this will become so that we can prepare it as possible. We don't waste time.
All right, thank you. Mr. Knight, would you share with us what your plan is, please?
Madam Hearing
Why is it
Examiner,
just me? Why is everybody else so smooth on the mic? I've done this a time or two before, but Madam Hearing Officer, Mr. Chairman, and Commissioners, pursuant to our notice of intent, we intend to call those 5 witnesses, I believe, in the order that they appear in our notice of intent. Yes, that is in fact the plan.
Thank you very much.
Yes. And while I'm up here,
Yes, sir.
are there any other opening statements?
No, there aren't.
May I call my first witness?
Yes, I'm only hesitating because it's 10:22.
Yes,
And I'm wondering if a 10-minute break would be appropriate.
yes.
All right, so you can arrange your witness and let's come back in 10 minutes.
Thank you.
Well, just need to go. Yeah.
It's like.
It is. And then one less sentence.
I don't think
Yeah. It needs to be back up. Yeah. That's one
As
Sure. I know. That's why I said. In the mobile. Yeah. Yeah. You need to. Yeah, well.
That's kind of spot on. Yeah, right, there's a lot.
Yes, many. Yeah. Well, I just had a bunch of things. Yeah, sorry. Exactly.
I have work. Option to go separate. Yeah, so. I ordered. Yeah. Yeah. Well, I mean, I. But not just straight up, but it has like used. I mean, it's used to pretty size.
That's right.
That's what he's gonna say. So he's raising. That's why I did it.
That last one?
I also told her.
Mm.
That's just.